SJC-10693, Camara versus the Attorney General.
Good morning, Ms. Sauber.
Good morning, Your Honor. Carla Sarber with the Fair Labor Division, and with me is Assistant Attorney General Anita Mayetta. We're here today on behalf of the Attorney General and the Division of Administrative Law Appeals. The Wage Payment Act is intended to prevent the unreasonable detention of earned wages, and there's a strong public policy consideration in the Commonwealth that underlies this enactment of this statute. In enacting the statute, the legislature recognized the employee vulnerability in the fact that there's an unequal bargaining power between employers and employees.
Well, certainly there can be agreements, I take it, between employers and employees with respect to the deduction of valid set-offs, whatever they might be. So what, in your view, is a valid set-off, and why isn't this one?
In the Attorney General's interpretation of a valid set-off, the meaning of that in the context of an employment relationship is that it's a clear and established debt that the employee owes to the employer. And the Attorney General has interpreted this to apply to only very limited circumstances.
Is there a dispute here that this was a valid debt or not a valid debt?
Well, I'm sure the employer would take the position there is no dispute, but it is the Attorney General's position that there is a dispute. That the employees,
was it disputed below?
If the employees are signing agreements that are characterized as voluntary, it's the Attorney General's position that when there's a waiver of statutory right, the statutory right to earned wages, that is an invalid waiver. It cannot be waived. And because of that, it cannot be voluntary.
So are there ever any circumstances where the employer and the employee can agree for a voluntary setup? I mean, in your brief, you mentioned this is not a case about an employee stealing from the employer or retaining property of the employer, because in those cases it would be okay?
Right. The Attorney General recognizes very limited circumstances, and that includes when there is a wage advance, such as an advance of vacation pay or other form of wage advance, a loan that the employer advances to the employee, when it's undisputed, the employee has stolen the employer's property.
When you say undisputed, do you mean that there would have to have been a third party that has adjudicated that?
Potentially, but it could be if the employee agrees that the employer advanced them vacation pay. The employee agrees.
No. I'm talking about the undisputed
Theft
the last one, the undisputed money that he stole or something like that.
If there were a circumstance where the employee admitted that they had stolen the employer's property, for our purposes, we would consider that to be a valid set-off.
So what's the difference here? Because if they admit that they had an accident and they caused X number of dollars of damage to the truck.
They admit that they may have been involved in motor vehicle accidents in the scope of their employment. However, that's not a debt that the employee owes.
So aren't you, the effect of this, it seems to me, is that you're forcing people to litigate issues.
It's actually the opposite. The Wage Act is intended to provide protection for employees so that they don't have to litigate whether or not they're entitled to their earned wages. The intent of the statute is so that they get their wages paid under the federal rule. They call it free and clear. We have a comparable analysis under the FLSA, the Fair Labor Standards Act. The underlying history is very similar to the Commonwealth's Wage Act.
So now the employer can say, well, we won't dispute this anymore. I'm just going to fire the guy.
An employer could fire an employee. There's no reason an employer cannot terminate an employee at will. The problem is when the employer deducts from earned wages. That they cannot do.
What would you say if the employer paid the employee the full wages, but then said to the employee, okay, I've decided, or my foreman has decided that you're responsible, so I'm going to, you have to pay me back $100 a week.
Right, and that's actually...
Gave him his wages, but you've got to pay me $100 a week.
That would actually be a constructive deduction. It's, in effect, a kickback, which is recognized, again, under the FLSA. It contemplates that.
Why is it a kickback? Because the employee could pay back out of his wife's salary, could pay back out of unearned income that he might have. Why is it necessarily a kickback?
It's a kickback because it's returning part or a portion of the employee's earned wages back to the employer.
No, it's not. It isn't necessarily. It's money, but I mean, money is fungible. But why, if there's a separate, if he pays the wages but makes a separate agreement? Because I'm intrigued by Justice Spina's question. Otherwise, you're forcing everybody into court to get a judgment and then to somehow collect on the judgment.
But that's actually what an employer would be required to do. The Wage Act is intended to provide broad protection for employees. It's unconditional. They have a statutory right to earn wages. We have a no special contract provision of the Wage Act. And in this court, in the DeFiore versus American Airlines case decided last year, there's a similar no special contract provision in the tip pooling
Let me
statute.
follow up on one of Justice Venus' questions. Let's assume that the employee doesn't want to be discharged, right, and agrees, rather than being discharged, to pay $100 for whatever reason, agrees to pay that. You've said it can be deducted, and you've just told Justice Cowan the employee can't agree to pay that.
Right, the employee can't.
So that means, what's the option for the employee who, rather than losing a job, which may have all kinds of benefits, agrees to pay, $25 a week or $25 a month? I mean,
Well, the alternative is, again, the protections of the Wage Act. The law prevents employers from threatening an
don't
employee.
tell me what they can't do. Tell me what they can do.
The employer could terminate an employee.
No. The employee doesn't want to be terminated.
Right, but the law should protect them. The law should not
no,
allow the
I
employer to
understand
threaten
that.
termination
I understand
on
that.
waiver of a right.
So are you saying that, in effect, are you saying the employer cannot recover for this type of injury?
They can't take self-help measures, and that's actually what this.
No, don't. They're not self-help. Just tell me. I agree. I'm an employee, and I agree that I owe the employer $100. And the employer says, if you don't pay me the $100 that you've agreed you owe me, right? Sometimes I go on vacation, sometimes I don't, sometimes it's because I've damaged some property or something. What are you saying the employer and the employee can agree to do?
What I'm saying is, if it is in fact a valid set-off, meaning it's an undisputed loan or wage advance, if the employee agrees they've stolen the employer's property or the employer otherwise obtained a judgment requiring the payment, that the employer and the employee can agree.
So the employer and the employee can go to small claims court or district court, file a complaint, have an agreement for the entry of a judgment, and then garnish the employee's wages.
They could do that, but in the context of an agreed-upon wage advance,
They would at
loan,
least
they
have to
wouldn't
do
have
that.
to do that. Well, what we're saying is you wouldn't have to do that. The statutory scheme contemplates a valid set-off for very limited circumstances.
But what's the difference between that? I mean, you don't question that if you get a judgment in a small claims court, right, that's a valid set-off, right?
Right,
So it's an agreement for judgment.
right. The difference is that the employee gets their day in court. If there's a judgment, that means the employee
You don't get a day in court if you file a complaint in the small claims court and there's an agreement for judgment entered.
Yes, but theoretically, I mean, the difference here is that it's a unilateral determination of whether the person is at fault and it was a preventable accident and how much the damage is.
And in fact, in here, one of the distinguishing characteristics is that the employer is the one determining liability and damages. There are no articulated standards. There's no appeals process of any kind.
That's a different question, but you've got two separate questions. First of all, if there is a proper process, or what kind of process should there be? But secondly, even if there is a process, can the employer collect anything from the employee?
Yes, if it is in fact a truly valid set-off, the employer can deduct that because this, in essence.
Okay, how do you get to a valid set-off?
Right. Well, again, the Attorney General has taken the position it's a loan or wage advance or theft or the otherwise obtained a judgment. And this is supported in some of the federal case law. For example, in the Mayhew super liquor store case that's cited in my brief, that talks about distinguishing between theft and intentional theft of the employer's property versus ordinary cash register shortages, which are
Could I
an
just ask you
accident.
this question? Is it possible, and I understand the argument about that it's a unilateral determination of the facts here, and then it may be that the employee agrees, but it's on condition of keeping his job. What if the company and the unions were to agree upon it, the equivalent of an administrative process? I mean, it's a private company, I understand that, but within the company process for adjudicating whether the accident was or was not preventable and what the damages are. Would that be okay?
It doesn't still qualify as a valid set-off.
Well, it
because
doesn't now because it hasn't happened, but I'm just wondering
Right. And
theoretically.
it's still, theoretically, it still would not qualify as a valid set-off. Essentially, what that would, in order to be a valid set-off, it's a debt that the employee owes the employer. And in the context of that employment relationship, it's essentially that the employee has retained the employer's property. That's why a wage advance or a loan it's in the affirmative defense. The employer's defense to that is, I already paid. The reason I don't owe him is I already paid him.
But aren't you trying to transfer this concept of a valid set-off into a prohibition of an employer assessing any damages to an employee with regard to non-adjudicated conduct? I mean, you're sort of taking that and you're saying you can never do it, even if the employer were to say, I'm going to fire you, but if you pay me back the $1,000 that you cost me, then I'll let you keep your job.
I'm not saying it can never be done. I'm saying it can only be done if it's a valid set-off.
Okay, but why can't the employer in that situation say, listen, you damaged this vehicle, it's going to cost me $1,000, I'm going to fire you, but if you agree to pay it back, I will not fire you?
A motor vehicle accident it's something that's ordinarily expected to occur if an employer owns a fleet of commercial vehicles.
But if you can fire, why can't you do something less than firing?
Because you cannot deduct from earned wages. The statute is designed to protect.
What if the employer says, okay, fine, I can't deduct because of the Wage Act. You owe me $1,000, and the employee says, I don't have $1,000, and the employer says, I'll loan you $1,000, and then that's an advance, and I will then do a set-off to take off the advance, the money that I advanced to you, to repay me.
But the employer really, under the protections of the Wage Act, the employer can't do that. If they want to, they could perhaps sue the employee, get a judgment against the employee.
What these set-off provisions are contemplating are automatic deductions, something that the employee has no control over.
Well, the employee can say, I quit. I'm not going to pay that.
But that's not always a viable option for a lot of people, particularly in this economy, particularly for low-wage earners.
Every answer to every question I've posed to you, you've left the employer with no alternative but to fire.
But the employer can't deduct from earned wages.
You keep telling me that, but you haven't told me what happens. Let's assume, I don't know the facts in this case, but let's assume that the employee signs a piece of paper and says, it was my fault. I leant down because a bee came in the window. I don't forget about those. You know, I was texting, and I went through a red light. And there's a police report. There's no question. I mean, nobody could question fault, right? And nobody could question what it took to repair the truck. And no, they didn't repair all 10 years of bumps. They just repaired just that. No question. None. No dispute. And the employee is responsible for $1,000 because it's a perfectly acceptable public policy for the employer to have. If you trash my property, you pay for it. And you're saying nothing can be done except to fire him.
I'm saying that the Wage Act has provisions in it to prevent an employer from deducting from earned wages.
No, but you haven't told me what can happen. Because you say, go to small claims court with an agreement for judgment. Well, you've at least got your day in court. That is form over substance.
But not really. The employee is not always going to be at fault. That's the bigger picture here.
No, I understand that. But the employee says, here's the complaint, and here's the agreement for judgment, and we file both at the same time. It happens all the time. And you're going to say we're going to look behind that and say, no, they can't do that?
But that's really circumventing the protections of this Wage Act. We have the no special contract provision, which is designed to prevent employers from coming up with ways to formulate agreements between employers and employees to avoid payment under the Wage Act.
But the assumption that you seem to be making is that the employers will always be making a judgment that is totally favorable to them and completely adverse to the employee. And either they're going to lose their employees, they're just going to quit on a wholesale basis, or the employers, isn't a good employer going to, or isn't almost any employer going to make some kind of an adjustment and listen to the employee as to what the circumstances were that gave rise to the accident?
Well, there's no requirement that they do that, and in fact, in this
But
policy, they don't.
it's a practicality.
But in this particular case, the policy is they don't. The employee has no right to appeal. They have no right to dispute.
Okay, so they quit, they file an application for unemployment benefits, there's a hearing before the unemployment office as to whether or not they violated the employer's regulations, reasonable regulations. The employment office determines that no, there was no valid basis for firing the person. They start collecting their unemployment benefits right away, and the unemployment insurance for the employer goes up. I mean, aren't there just practicalities in this situation that prevent abuses?
We see abuses all the time. The vast majority of the case complaints that come into our office involve some kind of dispute between employers and employees about these valid set-offs. So I would suggest that this isn't resolving itself on its own. In fact, this case arose because the employees complained to us. They complained that their wages were being deducted.
Yeah, I guess my concern is I'm aware of the risk of abuse, and we'll discuss that with Mr. Pontes, I'm sure, in a moment. But you say it's okay to do a set-off if an employer advances, if an employee comes and says, I'm short on my mortgage, I need $1,000, can you advance me the money? Then it's fine for the employer to set off, correct?
Absolutely.
But if the employer says, you were texting, you ruined the truck, I'm going to fire you, but if you pay me $1,000 to pay the damage, I'll give you a pass. And the employee agrees to that and says, I'm short of money, can I have $1,000? And the employer gives him that money. Then you say, no, the employer can't set off in
Right.
that. So it matters why the advance is made?
It matters what the circumstances are. You have to look at the facts and circumstances. It's not enough just to say there was some damage. I mean, there is no line with that. An employer could say, listen, you've been walking up and down this carpet every day for 5 years and it's worn away, and I want to deduct.
It's actually not helpful to the court. It's actually not helpful to the court to use examples like that, because there's no suggestion in the record that there's any such claim by an employer.
Well, we do have claims by employees that they're having wages withheld because of wear and tear to tools and equipment.
Well, we don't have that case here, right?
No, this case is dealing with the motor vehicle accidents. But
Right.
again, that's also the employer's property, and I would suggest that when an employee is operating a motor vehicle in the course of their employment, that is their employer's tools and equipment. That's something they need in order to do their job. They're picking up recyclable materials, so they need to operate the employer's vehicles.
Thank you, Ms. Sabler.
Thank you, Your Honor.
Mr. Pontes.
Please the court, Tom Ponch representing ABC Disposal and Mike Camara. Your Honor, our position is that
Who determines who's at fault here, that the employee is at fault, for example?
there's a thorough process and it's outlined in the agreed upon facts.
But it's your people. It's your HR person.
I'm sorry?
It is your HR person who makes the ultimate
Well,
judgment.
actually, it starts with the safety officer who conducts an investigation. It includes reviewing reports. It's an accident report that has to be completed by the driver at the time of the accident. There will be photographs that he's required to take. The safety officer will then review any police reports, insurance reports, interview the driver, interview witnesses, and any other information that's available to him. He will thereafter make a recommendation to the safety manager, who will then report it to management, who will make a final determination as to whether or not it has been an at-fault accident, the fault of the driver, at which point, according to the policy that's delivered to the employee on the date that they are hired, they'll receive an opportunity to either pay for the damage through a set-off or to just accept whatever discipline there may be. And I think it's very important to understand, and again, the agreed-upon facts state this, these are voluntary agreements. They're not required to sign these documents, and oftentimes they don't.
But if they're voluntary, why did the complaint arise?
The complaint?
Yeah, the complaint to the Attorney General's office. Somebody was unhappy about this voluntary agreement.
You know, they started doing this, Your Honor, in 2003, and it wasn't until 2007, I believe, that a complaint was filed. I can only guess. We don't know who the employees were. That information was not provided to us by the Attorney General. I can only suspect that it was some disgruntled employee, and everybody has them.
Well, isn't that some indication that it wasn't a voluntary agreement?
I don't think so, Your Honor.
Well, you say this policy is delivered to somebody on the day he's hired, right?
Correct.
He doesn't really have a choice about it, correct? He can't say, that's nice, but I'm not doing that.
They cannot take the job. I mean, it's part of the policy manual that is provided to everyone. Explain to them exactly how it will work.
What about the determination of fault that is eventually made by the, I forget the board, for purposes of insurance? Does that factor into your determination at all?
The insurance board for the Commonwealth, you mean, Your Honor? Or?
The board that determines if who's 50% at fault?
Motor vehicle volume.
Motor vehicle liability insurance board, whatever it is.
No, that isn't part of the process, Your Honor.
Well, what if they determine opposite the way that your people determined?
If that happened, then there would be. It's never happened. If it did happen, then they would have to revisit the topic.
So explain to me again, are there always insurance reports? What are we talking about? Does an insurance company essentially do an investigation and provide a report as to what they have found?
It depends. I mean, if it's a minor accident, you know, the driver backed up and he didn't use his mirrors or didn't look, and he knocked over a mailbox and it's going to cost $125, there's probably not going to be an insurance report. But there will be the pictures, there will be the interviews, there will be all the rest of the procedure that's followed by the.
I take it that one way to establish an appropriate record, leaving aside, you know, Masabo is given a very broad and possibly supported by the statutory language saying you just can never do this, you just can't do it, you have to fire the person. Another way might be to say we need to have an employee come forward and say, you know, I signed this, but I wasn't really at fault, but I felt I had to sign it. Let's assume that we have that record. Mm-hmm. Now, I know that the amicus briefs suggesting that all of these agreements are inherently coercive, but leaving that aside, let's assume that an employee came in and said, I wasn't at fault, I can explain to you why, you, Attorney General, why. I try to tell this to the employer, and the employer said, look, human resources person, I hear you, but I conclude that you were at fault. But I signed it because, you know, I'm going to lose my health coverage. What's your defense there?
That's a tough question, Your Honor. I would say that, again, that to my knowledge, that situation has never arisen. The employee is not required to sign the agreement and to agree to the set-off. And many employees have decided not to do that.
And then are they then terminated?
No. In fact, Your Honor, the fact of the matter is, and I believe that these are in the agreed-upon facts, no employee has ever been terminated because either because they had an accident or because they signed an agreement or because they refused to sign an agreement. The purpose of the agreement, Your Honor, and the policy is to prevent accidents. These are huge trucks. It's a real public safety issue. And in fact, again, upon the agreed-upon facts, the incidence of damages has decreased 78% between 2003 and 2006.
When you say, I couldn't figure that out, when it says the incidence of damages, is that the cost has decreased?
Correct.
78? Well, is that because the employees are shouldering it now?
No. It's because there are fewer accidents, because they're paying more attention to what they're doing, Your Honor.
You said that, if I understood you correctly, that no employee has ever been fired for refusing to sign a voluntary agreement or sign an agreement, but it doesn't really address the problem that maybe no employee has not refused to sign the agreement. Is it clear in the record that some employees have in fact refused?
Yes.
But nevertheless were not terminated?
Well, I don't think it went that far, Your Honor, but there is an agreed-upon fact that says that there have been instances where employees have chosen not to sign the agreement and have taken whatever punishment or
Which I take it typically would be a suspension for a period of days.
To be honest with you, Your Honor, it doesn't even usually arise to that. I mean, if a fellow backs up and knocks down a mailbox, they're not going to suspend the guy for a week. I mean, there's common sense that's involved. This company's been in business. It's a family business, started in the early '80s, and I represented them for many years, and they really take their employees to heart. But no, that hasn't happened.
Let's assume that yours is a good company and your employer is fair. What rule separates, in terms of this idea of a valid set-off, what rule would protect your so-called good employer from the employer who's not so good, who's using essentially any job-related event as an excuse to be debiting money from an employer or to be requiring the employee on pain of termination to pay for, the damage to the rug by a waiter at a restaurant or the kind of things which may routinely occur during the course of employment?
Well, again, Your Honor, that's not the case that we have here. The case law in Massachusetts, the Summers case in particular, indicates that if there is an agreed-upon debt for a specific liquidated amount, then that would be the subject of a valid set-off. In this case, we have a voluntary agreement that was signed by the parties, acknowledging the right of or I should say the obligation of the employee to repay the money that's been loaned to him or advanced to him by the company to pay his obligation to the...
But if we do that, then what can prevent the restaurant owner from doing the same thing to the waiter who spilled some gravy and caused the rug to need to be cleaned?
Well, the only thing I can say, Your Honor, is that, again, those aren't the facts of this case. If that happens, then that employer ought to be punished, and he ought to be...
But the problem is we're trying to establish rules here in terms of how we interpret this term valid set-off, and we can't really interpret it to say when the employer is a good fellow, it's valid, and when the employer is not a good fellow, it's invalid if the principle is if the employee signs something to say I owe it, then that's all that you need. I mean, I understand what you're saying, I understand what she's saying, and I'm trying to figure out here what rule should we put in place which should protect your good employer but not permit the so-called bad employer from using this as an excuse to essentially cut wages.
I think the rule that exists right now is the appropriate rule, and that's cited in the Summers case. The Summers case says that if you have a debt that has been, I want to get the exact language.
But how do we decide if this what you call a debt was in fact validly ascertained and wasn't the result of a contract? It's not a contract of adhesion or something like that.
Or how do we decide what you call a debt really isn't the cost of the employer's doing business? I mean, the employer has insurance precisely for this problem.
The debt in this case, Your Honor, is specifically, it's for a liquidated amount based upon invoices or appraisal.
Yes, no, I understand that. And I mean, we can argue about whether there's any participation in figuring out who's at fault, but assume that. Nonetheless, every company has as a cost of doing business that things happen to their equipment. That's not usually a debt owed by the employee. It is a cost of doing business. So one way of looking at that is that you are transferring to your employees what is a normal cost of doing business.
Well, that's somewhat true, but not totally true, Your Honor, because if that, in this particular case, again, where these employees are driving these huge vehicles in a real safety issue, if they cause an accident, they're going to be sued, and the company is going to be sued. The insurer for ABC, in this case, would then have a right to go after the driver if it chose to.
Yes.
For indemnification.
Yes, that's right.
So ultimately, they're going to be held.
But that hasn't happened. I mean, that's not what we're talking about.
Oh, I know, but I'm addressing your question, Your Honor, about whether or not isn't that a cost of doing business? Well, it's a cost of doing business, but it still ultimately can be the responsibility of the employee.
But surely in this case, at any rate, the Attorney General signed off on the fact that the reason why this company implemented this particular policy was to promote safety and decrease careless driving. the Attorney General didn't say it's the cost of doing business. I mean, she argues that, but she stipulated as a fact that here, the reason for this is to promote safety and decrease careless driving. Now, that may or may not be part of doing business, but I can, presumably employers can have various incentive programs and sanctions both ways to promote safety.
That's correct, Your Honor.
Can I?
What if
Can I-
there's, oh, sorry, go ahead.
I'm sorry, a couple of quick questions. So this policy is part of the employee manual,
Yes.
but when there is an incident and this investigation has taken place, the employee essentially is asked whether or not he or she will voluntarily sign an agreement to pay back through deductions or would rather take discipline. So is that the
correct.
voluntary agreement we're talking about?
Absolutely, Your
Okay.
Honor. I wanted to finish addressing Your Honor's question, Judge Gantz. I think the rule that we have already that says that if there's a valid valid debt, a debt that is due, that is agreed upon, then that in that case it is the subject of a valid set-off. Now you've got a factual question that can be raised by the employee or by the Attorney General as to whether or not, in fact, it was voluntary or it was valid or it is a real debt. Because not in this case. In this case, we agree. Everybody agrees that the
No, the Attorney
obligation
General
was
doesn't
voluntary.
agree.
Correct.
Well, let's say we're talking about drill bits, and the manufacturing standard is that a drill bit will last 1 year. You've got an employee, for some reason, he's going through drill bits every 6 months. The employer says, hey, look, this violates an objective manufacturing standard. You have to pay us for half the price of the drill bits because you're going through it twice as fast as somebody else. And the employee says, well, geez, I've got 3 kids that I've got to support, and the employer says, too bad, you pay this or you're fired. So the employee signs an agreement to pay for the drill bits because he's using them up at twice as fast as they normally is manufacturing standard. Is that a voluntary agreement?
No.
Well, how do we know that?
I guess that would be a question of fact, Your Honor.
Mr. Ponte, let me ask you this. We decide cases based on the facts in each case, not on hypotheticals, not on carpet wearing out. And in this case, the Attorney General has agreed that the scheme that you had is voluntary. Her representative signed the agreed statement of fact. The set-off agreement between the driver and ABC is voluntary. I assume that you would have no objection to a rule that says if the Attorney General agrees that a set-off is entered into is voluntary from the employee's point of view, from her point of view, then it is a valid set-off. That would take care of your problem, right? Because the Attorney General has agreed that the scheme is voluntary.
I just think that would be an overwhelming task for the Attorney General.
Well, essentially what it does is shift the burden to employees, and that may not be a good idea, but at least it provides a roadmap that says, in this case, the Attorney General agreed that the scheme is voluntary, and where it is voluntary, we're not going to force the parties to go through small claims or anything else. It's voluntary, and the set-off is appropriate. And then leave to another day the circumstances in which the Attorney General does not agree that it is voluntary. I don't know how that case comes about, but at least I don't have to guess.
I think that we ought to give the employees and the employer the credit of being able to manage their own affairs.
Well, you wouldn't to manage their own affairs, but not if it's coercive. Correct? And here, the Attorney General has said, this isn't coercive, this is voluntary.
Correct. If it's a matter of coercion, Your Honor, then by definition it cannot be voluntary. If it's not
Correct.
voluntary, then it's not enforceable. It shouldn't be set off.
Right.
Again, that's not the case that we have here.
Yeah, that she's agreed, it's voluntary.
May I ask a question?
Sure.
I'm confused about one thing. Does this policy apply only to minor accidents? Because if heaven forbid, an employee backed up the truck and hit a child or something, you mentioned something like that, I assume everybody would be covered by insurance and the case would go to court and there would be all sorts of suits. and then the insurance company would pay, and there wouldn't be, so this issue only comes up when there isn't insurance and when it's a small, that you don't want to make a claim because it's too small.
It comes up under any circumstance, Your Honor, and again,
But has the company made claims against employees when they hurt people?
not to my knowledge, Your Honor.
So,
Have the employees been involved in accidents in which people have been injured?
I don't have any knowledge of that either, Your Honor.
When you talk about sort of setting the amount, as I understood from your brief, it was setting the amount that the employer actually has to pay to make the repairs.
That's correct.
If there's an insurance offset, in other words, insurance covers most of it, but then there's a deductible, does the employee pay the deductible or the?
That's my understanding, Your Honor, yes.
So not the entire cost if there's insurance coverage?
No.
Okay.
and what if the insurance rate go up as a result of a serious accident? The experience rating, does that get passed along to the employees?
No, that's a cost of doing business. That's the whole purpose of the policy, is to reduce the insurance rate by reducing the incident of accidents. And in fact, that's what happened between 2003 and 2006.
Thank you.
Thank you, Mr. Ponte.
Thank you, Ernest.